Okay. Is it being recorded? Yes, it's being recorded.
Yeah.
Okay. Welcome Hammond North. It's July 16th, 6:03 p.m. for a board meeting. The attendance, Randy Vaughn,
Here.
Jan Welch,
Here.
Chris Conti,
Here.
Tom Deeds,
Here.
Tim Fritz,
Here.
Tracy Smiley.
Here.
Okay, so I'll turn it over to Randy for a motion on the minutes.
Thank you. Yes, I asked for approval I have two sets of minutes. I move that we approve the amended minutes of June 26th, 2025, that board meeting.
I
Do
second.
a second? Tim seconds. Any discussion? I think there were some minor edits that I gave Randy, and I think we've resolved all of those, right?
Correct.
Okay. All right. No questions? All those in favor of approving the minutes? And it's unanimous. All right, the second motion, Randy?
Yes, I move that we approve the minutes of the board meeting of July 2nd, 2025.
And the second? Tim seconds it again. Okay, any discussion? And again, there are some minor corrections that Randy and I talked about from the ones that went out. Okay. Sally, I don't know what happened there. Hang on a second.
John, can you put remembrances after announcements?
Just one second. I'm trying to, does everybody else have the white screen?
I got
Yeah.
the white screen.
Yes, I don't know what is going on there.
Jan, it says Jan.
There we go.
Done.
Okay. Bear with me 1 minute and unmute themselves. That should be it. Okay. All right. I don't know what happened there. I'll talk to Sally later. All right. Let's turn over to Jan, some remembrances.
No, we have to
got
vote
the-
on the
Oh,
minutes.
I'm sorry. That's right. Okay. So all those in favor of the minutes of July 2nd? And that is unanimous also. All right. Sorry about that, Randy. All right. The next item is Jan Welch about some remembrances.
Yeah, during the past month, we lost another of our owners' members. It was Lillian Dean in 1010, and I think her funeral was just Monday, and several people went there, and we mourn her passing.
I think we also lost Bob McGrady from 1603.
Oh, really?
He died some time ago. His son was traveling, so we just recently found out about that.
Thank you.
Yep. All right, thank you, Jan. So Jan, do you want to next one is announcements, the votes on the waiver of the reserve account?
No, you do the partition update first, please.
Okay. Petition action update is that the petition was filed on Monday. It's a 168-page document along with an attachment. It went through extensive review and editing by, I think, primarily Randy and I. I think Tim saw it also, trying to get everything consistent with all the governing documents. But it is, that's one of the questions we'll get to. It has been filed. The next step is that has to be served on all the owners who are defendants, and it also has to be served on the banks that have mortgages for any of the owners. So that is going to be a time-consuming process. And if there are problems with the addresses, the board and Greg will try to help out Finney as much as possible to do that. But that is the petition update at this point. Are there any questions about that? Okay. Oh, Randy?
Yeah, well, there's one in the chat here, I guess. It says in today's filing with the court, the claim shows quiet title, which means ownership disputes. What's in dispute? Do you know anything about that? That's a new one to me.
I do know, I haven't heard that word quiet title, but I do know there is a dispute among two owners who are both listed on the property, and they're listed as different the legal attorney, the legal document POA is for two different people, and there's a disagreement who has the right to speak for one of the owners. So I assume that's what it's about, but I don't know. Any other questions in the chat?
I don't believe so. Wait, no. Well, someone answered that other chat question by saying that a quiet title cleans up any issues with a title. It's not a dispute. It has nothing to do with a quiet title. Okay, well, anyway.
Carolyn, if you want to speak on, since you put a chat in as to what a quiet title is, I don't know what a quiet title is. That was just my guess. If not, then we'll just proceed. All right, so that's petition action. Jan, the
So,
votes on the waiver reserve account?
yeah, I don't have the exact number here. I'll probably have it before the end of the meeting, but it's up, I'd say about a half dozen. We're getting close and on the waiver of the reserve account, I'd say we need about 7 more votes to approve that. And I think we're at about 10 or 15 shy of the 75% on the vote to sell. But as you know, we currently need 100% in order to vote to sell. We have a committee that's working, and it's kind of an exciting committee. It's got a lot of owners, and so some of you may hear from different owners. It's really encouraging to see the way everybody's stepping up and volunteering to contact people. So that's happening, and I think you'll hear a lot more in the next week or two. Okay, so Michelle's asking, and Anne, who are the members of the community? It is Lynn Saul, Carolyn Ford. Let me get out my folder here. Chris Conti, Tom Deeds, Ginger Rhodes. I think that's it.
No, we got Dave Waybright.
Oh, and David Waybright, thank you.
So Carolyn,
Yeah.
you're unmuted. Can you fill us in about the quiet title?
Yeah, so I've done a couple of quiet title actions when I was a paralegal. So what a quiet title action is if there's a problem with a title, so they didn't get somebody to sign on a deed, or a notary's missing, or the legal description is wrong, or someone has a piece of land and nobody knows who owns it, and nobody's paid the taxes or done anything, and the neighbor wants to buy it, they can do a quiet title action. And the quiet title action actually just cleans up the title, clears the property, and then the court allows that person to purchase it or gain title to it, gain clear title to it. So that's all it is. It has nothing to do with disputes between people.
All right, thank you.
You're welcome.
Marion, you have a question? Can we unmute David Bromley?
Can you hear me?
Yes.
Yes.
Okay. Two quick questions. How many people signed for the petition action, or what percent? And then how close are you? I didn't quite get what Jan said about for the reserve account. How many have voted for that?
So, Marion, I'm sorry, I don't have that number right here in front of me, and I should, and I will have it by the end of the meeting.
Okay.
But I
And
think
don't have
then,
the petition.
what Jan recollected is what I recollect. It's around 117, 118. We need under 10 votes for the reserve account to pass.
But you were the partition, John.
Yes.
Just asking about that part.
I know that. I was answering your question in terms of my recollection of the
Okay.
reserve account.
Okay.
And the petition?
The note from Greg on Monday says waiver reserve funds total to date 128. Consent to sell 124.
Okay, thank you.
Okay. I'll move on to the next item, which is a treasurer's report. That's Tracy.
Yes, so for the treasurer report, this will be the report for June. So for June, we opened our account balance with 157,414. We had a reserve balance of 2,889,578. And then our ending account, I'm sorry, our reserve ending account is 2,889,578. I'm going to go through the delinquency report as well. So as of July 14th, we had approximately 49 delinquencies. So that is owners who owe more than 30 days. And that total is 598,579. And that is up from the previous delinquency report about 74,000. And that last delinquency report was ran end of May. So it's a couple months.
Thanks, Tracy.
No problem.
I would just answer David Rosenberg's question, previous stuff, which is that items as to why people are not voting for to sell. And I'd say that there are diversity and many different reasons, and that the committee is on the sell on that vote is talking to people and trying to understand, I think, what the questions are and try to hopefully get people to sign.
Yeah, or come up with recommendations.
We had an owner approach us today and talk to us about that, and they indicated that there was some discussion about that the resolution was not clear enough. And I asked them to please tell us exactly what they're looking for to clarify the resolution. So I'm hoping that in the next day or two, we'll get some more information on what exactly those owners are looking for in terms of clarifying the resolution.
Okay, moving along, building and grounds report. That's Jan.
We've not met. We didn't plan to meet because of the other things going on.
Contract committee, Tim.
No update.
Health and safety.
On that, John, we've had a meeting this morning. And our concern is about freezing in the upper part of the building during the winter months. So what we did was we decided to meet with Halpy to give us some guidance. Halpy is a contractor that has worked in the building before, very familiar with the building. Most recently, they've worked for Dennis Back. And we met with the engineer, who is a licensed engineer in the state of Ohio, an HVAC specialist, and mentioned the problems with our concerns about freezing, especially in the winter months. And we talked about different possibilities such as, H&V. We're not going to put H&V in unless we get a recommendation from them that it's needed to keep the building from freezing. And they will get back to us. Concerns still are freezing, but also water getting blown out of lines because water may settle in low points like toilets, U-traps under sinks. So we talked about solutions to that, and I think we're waiting for him to get back to us with some information.
Yeah, he's gonna do a load calculation, and he's gonna basically do it for free. He said, I've worked here enough, I know this place, and I can, in a few hours, I can do some load calculations. And then we talked to Tim and John were in the meeting, our maintenance guys, and they're gonna start trying to prep the building probably sometime in September. And our goal basically is to get the building as drained as we can, and then provide some minimum amount of conditioning to keep the building from freezing up. So that's the plan. They basically what came out of the meeting is that the building was never designed to be drained. So we just have to make sure that we get as much of the building preserved as we can.
Any questions about that report? I'll just answer the question about can you file a petition filing? We will post the brief, and there is a case number that was assigned, and we'll add that to it. Okay, legal, Randy?
Yeah, there's nothing too major right now to report. We do have the two legal cases going on. There hasn't been any development with either of those since the last meeting. Not really much, at least not that we know of. Our lawyers have been busy, as John mentioned. The petition action was just filed yesterday, I guess. So that's taken a lot of their time and effort. And then they're also reviewing an offer that we had on the building, and but all of this is happening even as I speak. So that's really about all I can report at the moment.
Any questions for Randy? Let me just answer one of the questions. We'll ask, has the order to move up and lifted? It has not, but we'll get to more about that. There's one of the questions from the owners when we do questions and answers. And also the other questions, yes, we are concerned about the property, and there have been some incidences. Cars broken in. We know people have basically cased out the building, very suspicious incidents, and we are concerned, and Chris Conti is leading the board's effort to try to figure out how we can secure the building. And some of that probably we'll try to do as soon as possible.
John, there was also a question about whether or not we have a case number to file with the partition action.
Yes, as I said, I will post the partition brief as well, which is somewhat structured a little bit differently, largely what all the owners got to look at, and we'll add the partition number so you can look up documents online.
Okay.
So next item of business is new business.
One second, John, the finance committee.
Sorry about that. It wasn't listed. My apologies.
That's all right. So the finance committee did not meet last Friday, but we what I've drafted was a payout for the remaining insurance funds plus an estimate of the sale of the building to calculate what each owner will get once we sell the building. I've drafted that. I've shared it with the board. I'm going to send it over to the finance committee to get their eyes on it next week. I will be out on vacation next week, but I'll send that over for them to review it and make sure that everything is calculating properly to share with the rest of the board the next go around. So
Thank you. Any questions about the Finance Committee? Okay, and the answer for the question about the basement storage units, again, we'll get to that when we talk about this, that item. So the next for new business, Greg is on vacation, so he's not on this call. So he's provided financial information to Tracy, and usually Greg reports violations, and there was one violation. It was a first offense, and there was no fine to that. Then the second one, harassment, proposed policies in Blue Book. That's Randy.
Yeah, John, can you allow me to share on the screen?
Sure. Let me just. As co-host, you can't do that?
I can try. Hold on. Not having a lot of luck here.
Yeah, I'm not having much luck. Somehow the host, I'll tell you what, I'm gonna make you the host. You should be able to do it now.
you're trying to share your screen?
Yes.
You click at the bottom, share, and then send requests. There we go.
There it is.
Randy, you're muted.
Okay, so these are this is a proposed change in the Blue Book. This has been around for about 6 months. I think this was created, but we never did act on it. But it's sitting here. John, can you watch what's going on? Okay. Anyway, as you can read it, you can see that it has to do with harassment. Section 14.3 of the Blue Book is labeled types of violation. That's really kind of misleading. It isn't types of violation. What it is it's various board responses to reports of violations. And so one of the proposals here is to change section 14.3 to read either types of violation notices or board response to reports of violation. That's minor. The actual document that was proposed and is being proposed is should be placed under section 16.17, which deals with discrimination. We propose increasing that title to say discrimination and harassment. In black is the original wording under that section. Basically, if you can't see this, I'll just read it real quick. Neither any occupant nor the association shall discriminate in violation of any local, state, or federal laws against anyone due to their gender identity or sexual orientation. And that's also referenced in the declaration. We propose adding a number 2 to this that reads, wait a minute. I'm just doing my hosting duties here. Neither any occupant nor the association shall engage in harassment of other owners, guests, building staff, or contractors. Harassment is considered to be behavior that a reasonable person would fear for their safety or well-being, including verbal threats, intentional property damage, stalking, preventing egress, intimidation of others. And intimidation of others is broken down into, for example, using vulgar slurs or derogatory language, targeting a person's color, ethnicity, age, sexual orientation, etc., threatening jobs security, and physical contact. And we have noticed that that has not specifically been placed in the Blue Book before. And it seems that maybe it would be time to do that. So I guess, should I make a motion then, John, that we adopt this language into the Blue Book?
Yes, however, the process is it needs to be posted for all the owners. I have to look at the Blue Book section revision, and it has to be posted for 30 days before we can adopt it.
Yeah.
So I think we could just agree that we're going to post this language, and then within 30 days, after 30 days, we can propose to adopt it.
Mhm. I have a question, Randy.
Yeah.
Isn't, aren't we leaning toward giving people a warning before we go into issuing any type of monetary fines first?
Yeah. Yes, that's
I mean-
under 14.3, which I suppose I should have reproduced to share here as well. But 14.3, it lists various steps. And for a first violation, it basically is just a warning.
Mhm.
And then for a second violation of the same type, there's a monetary fine attached to it. And then there's a third step and a fourth, which escalate the amount of the fines and the actions that the board can take. So yeah, that's already in there under 14.3. And basically, if you read that 14.3, what we're talking about is violations of the governing documents. And we noticed that harassment is not really in the governing documents. So we've decided to add that to make that more complete. I think our thought earlier, to be honest, was that, we're trying to sell the building. We're trying to bring an end to the association here eventually. So we thought, well, maybe this might be, as someone once said, this is like maybe trying to arrange the deck chairs on the Titanic. But it seems obvious with some of the hot button issues that we now have going that, tempers can flare up. And so maybe we need just to address this issue.
Thanks, Randy. Are there any questions?
And I can't see anybody, John, so you'll have to do that.
Okay, so if you could stop the share, it's easier to see everybody.
Okay, and so if there's no objections, we'll post this on the bulletin board. We'll post this in the under announcements in the on the website. And I guess we could also put this out as an attached document to a one call as well.
That sounds right. All right, with no other question on that, we'll go to the next item, old business, which again is Randy, the question of the deadlines for removal of property.
Yeah, at the previous meeting last month, there was a motion to set a deadline for removal of all belongings from the building. And it was seconded by Tom. But before any discussion, it was moved to table that. And we really need Greg's input on this. since he knows the staffing and the ability to, facilitate any deadline. So I would move then that we table this again until the next meeting with Greg.
There have been some questions that were raised in the questioning process about how this impacts the costs of the building. And I guess what we think is that we're going to reduce maintenance down to a bare minimum at some point in time. And it would be very difficult to have an absolute bare minimum maintenance staff when there are still people that need to be getting in and out of the building and going to their units and being accompanied and stuff like that. So that's how this all plays together. Is we're trying to make the budget that Tracy came up with fit the schedule of getting people out of the building, so that we don't have a requirement for additional staff around to assist owners.
Thanks, Tim.
And in Greg's absence, again, I would repeat that I move we table this until the next meeting.
Is there a second?
Well, hold it. It hasn't been brought off the table, has it?
No, it was tabled
No.
before. And if it's
It was
not,
brought up for tonight, but I don't think we're ready to intelligently discuss it, but I don't know.
I think the table just stays in force.
Yeah. We don't need to.
Okay. We don't need to move, we'll just table it then. Okay.
Yeah, we just continue to
right?
table.
All
Fair
right,
enough.
kick it down the road. All right.
Okay, then we didn't have it on our agenda, but I know Tracy, you have some bills you want to present tonight?
Yes. All right, so I make a motion to pay Griffin, Fletcher, and Hughes for the 182 exam title searches. That was just performed in order for us to move forward with the partition. That is in the amount of $20,240.
Is there a second? Tim seconds. Any discussion about this?
One question. That's done now, right? The title search?
Yes.
Yes.
Good.
And I think we looked at a couple of cases as to what it would cost, and this was the most economical bid that we had to perform these titles.
Yeah, we discussed that with a number of people, and actually Finney was surprised at what we were able to get it done for.
Mm-hmm.
Okay, excuse me, was there a second? That
Yes.
was Tim?
Tim.
Okay. Any other discussion? All those in favor then? Okay, it's unanimous.
Next
Second.
up-
Yep, sorry, go ahead.
Now I was just gonna say, next invoice that I make a motion to pay Seal. Seal has an invoice in the amount of $499,176 for the recovery of insurance funds of $6.655 million.
A second.
Okay, second by Jan. Any questions or comments?
Ouch.
Yeah. And this pays Seal in full to date, unless they collect more money, correct?
Correct. That pay Seals in full to date. There is approximately 11 million still left to be paid out from insurance, and then it'll be 7.5% of that 11 million.
And we held this longer than we've ever held.
Yes, we did. We've held both payments longer than we normally would.
Any other discussion? All right, I'll call the question on the bill for Sil. All those in favor? Okay, unanimous. You have more bills?
The last bill that I have is for Perron. Perron actually performed the fire particle sampling on the floors in order for us to remove the air blowers in the hallways. And that is in the amount of $7,140.
Second.
And Tom is second. Any discussion about this? Randy?
Yeah, Tracy, can you repeat that dollar amount again?
$7,140.
Thank you.
And a second by Tom. Any other questions or comments? All those in favor then? Okay. Yeah, opposed or abstain? Chris, did you raise your hand for it?
I did.
Okay. All right, unanimous. And that's all the bills then, Tracy?
Yes, John, I think you and I were talking about some of the Finney invoices. I did see that note come across about a credit, so we will hold off on those until we review the outstanding balance, which should be bare minimal because of the credit. So I may send that motion through email if there's any remaining balance for Finney.
Thank you.
That is it.
Okay, those are bills. Randy, any of the chat that we should answer?
Okay, there's a couple, not so much about these bills. One about the harassment proposal. It says harassment was addressed in the revision of the bylaws. A complaint process was developed during the time I was on the board and Conti was president. Please look at prior board work. No need to reinvent the wheel. We addressed this issue when a security guard was disparaged by an owner.
Well, Chris, you should probably send an email to the rest of the board when you get back from your trip, and we should take a look at that. But I think we looked at what the Blue Book said, and we felt that it needed to be strengthened. That was the logic why we did it.
I can tell you what I can recollect right now, and that is when we were working on revising the declaration and bylaws. Our attorney, Cassandra Edwards, recommended omitting a harassment section in the declaration. Her reasoning, I can't get into the details of that because I don't recall them, but I do specifically recall that. I don't see any reason we shouldn't put it in the Blue Book, but she recommended against it being included in the declaration. So that's what I have to say about that.
Okay, thank you.
Yeah, Randy.
And we can look into this.
Yeah, Randy,
next meeting.
you looked for harassment, right? And didn't find anything that
Right, nothing specific like this proposed wording.
Right, okay.
And then there's another question. We might get into this later, but it's when will the final 11 million be received? I guess that's from Landmark.
Yeah, that's a question we're going to address in a little while.
Yeah. And let's see. Well, again, we haven't, we tabled this motion, but there was a suggestion that we have 2 security guards in second and third shift. Couldn't one of them escort people up to their units? Again, we haven't talked, we tabled that, so I don't know.
The issue with that is that the power is off on most of the units, and to go to the upper floors on second and third shift is not feasible.
All right, and I think that's really about it for chat at the moment.
Okay. Tim, do you want to say anything about HVAC units to be installed? Or you want to wait for another time on that?
Tom's going to cover that. You got the list of questions. Let's just go through the list of questions.
Okay, fair enough. Okay, so the questions. I think, Jan, you have the first section on voting for direct sale of the building.
Right. So there were 2 questions that specifically talked about changing our declarations or bylaws to 75% of the people being required in order to sell the building instead of the current 100%. And it's a great idea. We certainly talked about it a number of times, and I'm not sure that we won't talk about it again. But technically, yes, it's possible to change the declarations or change the governing documents so that we can do that. However, we have talked to our attorneys about that. They advise against that. That doesn't mean we couldn't do it. They've looked into other things for us when we wanted them to. But what they said, and I'll read part of this here, is that individual property rights are strongly protected, and the courts have a tradition of upholding these rights. Our attorneys have stated that no one can be forced to sell their property without an express legal right. This is the purpose of the partition option under Ohio law and the declaration. So the partition approach to selling the building is one that allows for less than 100%. And, I know there are complications with that too, but it's an express right and process to force another party to sell is something that a judge oversees. We could ignore this advice and proceed anyway, but if we do, the likelihood is that we'll be sued for having done so, which results in more legal fees and another lawsuit. So, I mean, those things can be cleared up. It's a very tempting possibility, but that's where we are on it.
All right, do you want to go on to the second question in that group?
The second question was the same. You mean the part about the?
No, I guess you're right. I guess it's with Deborah Modals. And if you want somebody else to handle some of them, we can step in.
So how can mortgages be resolved before the sale is closed? I think the answer to that is if you sell, you can still sell your unit, or you can, your mortgage is with your mortgage company. And, if there's a way you can resolve it, that's between you and them. There's nothing in any of these processes that gets in the way of any of your business with your mortgage company. Will we be informed of how much money we will receive for our unit before the sale is closed? I would guess yes, but there's a big question as to how much that would be. And there are, there are lots of possibilities there. What if the mortgage cost is not covered by the sale proceeds? I think we have talked about that. John, do you, or?
Yeah, I mean, that is a very
Maybe.
difficult situation
Yeah.
because certainly we know how many mortgages there are without knowing who has them. And we know there are a number, and some of them are a good deal of money, which probably would not be covered by the sale of the building. They have to be resolved by the time of the sale. Partition action, we're hoping the judge can make a verdict on that. We're hoping that some of the banks might realize that this is the best deal that we can get at this point. But ultimately, on the direct sale, I believe it's stickier. And there it would need each bank and each owner to reach agreement because a buyer of the building will want all of those mortgages resolved. So that's the best of that. There is a question that Deborah said the name of the person business offering to buy the building. And that is Mike Stacy, who was an owner of the building, owner of 2 units. And we're in ongoing discussions about offers and making sure that we can protect all the owner's interest as we proceed. But the main 2 routes on selling the building, as everybody is aware, is that either direct sale, getting 100% of the owners, or partition action. So possessions and move out. Well, let me just add, we didn't talk about this beforehand, and this is not the way we did questions before, but if Sandy Allen or Marta and Tom or Deborah Modal, who asked those particular questions, want to make a brief comment or add a follow-up question, they were your questions. So if you raise your electronic hand, we can recognize you. And if not, then we'll proceed. Okay, possessions and move out. Tracy, you want to do that one?
I can. I wasn't listed, but I can.
Well, we've been in more of the meetings, so you've been working. So I'll answer them, and maybe Tim, you've been at the meetings, you can, anybody else on the board can chime in. And these relate to questions that came up earlier. One from Barb Gleckner, does it mean to move all your appliances, vanities, light fixtures, vertical blinds out by September 30th? At this point, the personal items, furniture, the deadline for that is a week of August 4th. So that's the personal items, furniture. For the other things, cabinets, appliances, vanities, we have a deadline that's a few months away, but that's exactly what the motion we table. And everybody should know, we talked about it before, so we believe we're going to move up the date for the cabinets, appliance, vanities, and all possessions. Actually, I take it back. I misspoke. The August 4th, and the board was willing to correct me, I'm sure. August 4th is the deadline, the week of August 4th, for the owners to move out, not the possessions. So at this point, the possessions are much later in the year. September 30th was a proposal that we tabled. We didn't move it to September 30th, but let me add that there are, I think, about 3 different types of possessions to think of. One is personal possessions, that's 7th floor and below. 2 is appliances, which is refrigerator, stove, microwave, cabinets, and that's the whole length of the building. And 3, I think, is the lower level. And I think, quite frankly, that it's going to be in that order if we change it. That's my personal position, but the board hasn't changed the dates from what they are currently.
And what is the current date?
The current date is the end of December.
Okay.
But we're basically trying to minimize costs, and to minimize costs, we have to close up the building, and to keep it closed up, we need to seriously move those dates up.
John?
And we need people to some of the owners to contact Greg or someone on the board to sign up to move their items. So in that way, we can develop a schedule to ensure that we do have someone on staff. I thought we were keeping a list. I don't know, Tim or someone was keeping a list of individuals who was saying, yes, I want to get back up into my units to remove their possessions. And if we create that, then maybe we'll have a better chance of expediting the move out process.
Randy?
Yeah, that's why I thought we should table this until Greg is here, because he has that list. He knows, I understand, last I had a conversation with him, that there is a bit of a backlog. People are requesting to get up to their units, and we can't get them up there fast enough. So he needs to sort of, if we're going to start talking about a schedule, definitely, then, he needs to have some input in that conversation. And then there's another question here concerning this in the chat. According to an above chat comment, the building is being closed temporarily in August. When is that specific date? I presume we can't pick up our mail pending the reopening of the building. When will it reopen? Assuming the above comment about the closing in August is accurate. Beyond that, when can we no longer pick up our mail?
And the board hasn't made a decision on it yet. I think it's been mentioned in earlier meetings that we encourage people to have a change of address and forwarding the mail. There's a limit when you use the post office as to how long they'll forward second, third class mail. So it's tedious, but I advise people to notify different agencies that they get mail from, banks, bills, etc., what their new address is. There was also a comment, a question, do we have to remove all our appliances if we don't want them? No, you do not. But that's exactly what Tracy was saying, is we need to have a list of the units. And Greg and I have talked about that. We need to know the people who don't want to remove anything else, who have all the possessions out, so we can approach this in a systematic manner. Jan?
That's the first time I've heard of what's happening after the week of August 4th referred to as closing the building. I can see how you would think of it that way, but that is the time when everyone has to have moved out, right? I mean, correct me if I'm wrong, and people are supposed to be getting their individual furnishings and personal possessions out, except for their cabinets and appliances and things like that, to the degree that they can. But I think that the building will still be open for probably a few weeks. We haven't really come down on that, and that comment may help us.
Well, I think that the mail date should be the same date
Yeah.
as having to have all your possessions out here. So if we come up with September the 30th or October the 15th or whatever we come up with, that is also the date where come and get your mail will not be allowed anymore either.
That makes sense.
Steve?
Yeah, I just heard two different statements. One is by the week of August 4th, we can no longer spend the night. And one is that by the week of August 4th, you have to have your possessions out. Now, let's be very clear. We have already made arrangements with the moving company to move our possessions on August 13th. And we will be out before August 4th in terms of spending the night. I want to be clear that that is in fact the statement. John said one thing and you said another. And let's please be clear.
No, I'm sorry if it's not clear, but here's the statement. People cannot live here any longer after the week of August the 4th.
Right.
You may move your possessions out after the week of August the 4th. And we're trying to determine the date that you have to have your possessions.
Right. Thank you. That's what I thought. That's what I thought.
Your plan.
No, I misspoke
your
in the
plan
beginning.
complies
I
with what
tried,
we need.
yeah, I tried to correct it, but.
What was the last thing you
Tim's
said,
correct.
Tim? I couldn't hear it.
His plan complies with what we need to happen.
Thank you.
Okay. I think those are Jan's, that's the way. Now, the Lynn Saul's another question. What is the final date for all items for out of the building? Items, units and storage bins, and at this point, it is the end of December. But as we said, the appliances may be moved up for the date for that to be out, and all possessions.
And I don't
Storage-
think people should count that won't be changed. I think I mean,
Right.
all the discussions have indicated we really should try and move that up.
Yeah, our budget reflects that we won't have people here after October to do this stuff. So
Yeah, we would
all-
only have one maintenance staff after October.
right.
So we made the decision for December 31st, but probably.
Well, that went way back to the first discussion with the
exactly.
city.
Exactly.
That's real old information.
Yeah.
Okay, so the next section is on litigation. Randy, you want to handle those two questions?
As well as I can. The question is, what is the likelihood that as a result of the Porter et al. Lawsuit, that the D&O insurance company will actually pay funds that will provide substantial income to the HOA? Many of us are confused about how their lawsuit going to a jury is supposedly a good thing. Another related question, will the lawsuits be settled with money from the D&O insurance, or will we all have to share the cost of settlements as a community? I can only tell you at this point what people have said and what I know. Our D&O insurance carrier, CNA, they have said that they will provide an attorney to represent the association in the Porter case and also in the Cross Creek case, and they have done that. They have hired Ian Mitchell of the Reminger Law Firm to represent us in the Porter case and also in the Cross Creek case. CNA has stated that they would pay no damages because the Porter case sought injunctive relief, and that is not covered by the D&O policy. Now that the case has been remanded for a jury trial, if issues other than injunctive relief arrive, then who knows? Maybe the insurance company will cover those damages, but we have no way of knowing. We're trying to look into the future there, and we can't do that. So that's purely speculation on my part, because that has not been addressed at all by the D&O carrier. And additionally, as yet, there has been no talk of any kind of settlement. So I guess at this point it's premature to ask, who would fork over money in a settlement, because we don't even know that we're going to have a settlement, other than whatever the court decides. That's about all I can really say about that.
All right, thank you, Randy. I don't know if Steve Kaufman, you have any, or Deborah have any particular comments about that? Okay, let's move along. Insurance for damage. What is the status of the $11 million? Sorry, this is Tim. The question from Steve Kaufman.
Yeah, we've been in continual contact with our insurance company. What the status of the situation is right now on that additional $11 million, the last $11 million of the policy, is that Landmark has changed their strategy on how they're approaching the case. And they are asking, they're basically saying, what's it going to take to settle this case? Which means that they are fully expecting not to pay the $11 million. They're expecting to pay something less than the $11 million. I wrote a letter with the help of the rest of the board the other day to SIL and told them, in no uncertain terms, we expect the entire policy to be paid, $11 million, and that we will continue to pursue the settlement. Now, it gets a little complicated because we're not finishing the building, and there's some depreciation that comes into play, and replacement cost value versus actual cost value. So we may not get the entire $11 million because of depreciation and because of replacement cost value stipulations that are in the policy. But we have told SIL that we want to collect the maximum amount of this policy, and that in no uncertain terms, that's what we want. We also told them that since we moved into this new situation with them, where they're, up until this point, what they've been doing is arguing about how much damage there was. They've been quantifying the damage. Every time Landmark comes back, they want to know how much damage there was and why we think this damage costs that much. So they've been in this quantifying the damage mode up until now. And they've moved out of that mode. So we've told Landmark that since now we're in this negotiation phase of a settlement, we want to participate in those meetings between SIL and Landmark. They had recommended against that up until now, but we're sort of saying we want to be right in there with you. We don't know that we can add any value, but we want to make sure that Landmark understands how serious we are about this, and that we want to push this thing as much as we can. So Jason, who is our representative with SIL, said he understands and that he will keep us apprised of the situation. He's on vacation this week, so the communication this week is going to be slight, but we'll get back into it as soon as he gets back to work on Monday. Are there any questions? Steve, that was your question.
Can you unmute Steve, Randy?
Yeah, thanks. I just think it's important for people to understand that that 11 million is the key to making any money out of this deal. And that unless somebody offers 20, 30 million for the building instead of 12, and that
people understand how important this is to receive some kind of return on their investment in the forthcoming HOA fees and so forth.
Right. And that's why we wrote the letter and told Sue in no uncertain terms, we expect to be fully compensated for every penny that we're entitled to in our policy.
Good.
All right. Moving along, the next one was petition action, and the question was, when is it going to be filed? Which it has been filed now. In terms of the other parts of that question about buyers and potential benefit of it, I think that we've talked to brokers, we've tried to see what the worth of the building is. We think that it could be significant, but we have to wait and see what they say. It has a benefit, one, for partition for when it gets sold, but hopefully seeing offers may convince people who have not signed the direct sale to sell them. Will it get to 100%? I don't know. But I think if we get to 160 votes, I think there's a good possibility it may. And I think it's worth the effort. But again, we don't know what will happen in the future. So again, that's your question, Steve. I don't know if you have any follow-up to that one. Okay. The next section is on HOA fees. Question by Steve and by Carolyn Ford. Tracy, I have that as you. We're going to do that.
What was the question?
One is people are not paying their fees. Will the unpaid fees and penalties be deducted from future payment from a sale as a given? Will the HOA put a lien on unpaid units? Will people behind be reported to credit bureaus? I think that's the gist of it.
Yeah, so I also received another question through email about the fees and late fees as well. So if when the building sells, if there are any past due fees, those past due fees plus any past due interest or any charges will be deducted from the amount that the owner will receive from the sale. As of right now, we are not foreclosing. I know that there are liens that have been placed on properties due to that process, and that is according to the bylaws on how that process works. I did report out on the number of delinquencies earlier today in this meeting, and we'll continue to keep track of that as well.
I'd also say I've had discussions with both Isaac and Greg of applying a lien to units that have fallen behind per the procedures that we've had. There's a 30-day letter, 60 days, then a lien is applied, and we have to make sure that that policy is implemented.
And in past discussions, we have said that we will apply liens, but we will not report to credit bureaus.
Right.
So that's still the policy that we're following. We will apply liens. We will not report to credit bureaus.
And it will be deducted from any proceeds.
So the second question, Tracy, was as owners, we are entitled to the names of those owners who are not paying their dues and being subsidized with those owners who pay. There's nothing in the government documents to say the information must be secret.
Well, owner's financial information is personally identified information that cannot be shared because it is personally identified information. Other owners who are paying are not subsidizing for other owners. When we went through the budget and we reduced the fees for all owners across the board, we do know that there are some who are not paying, but in no regards are you making up that difference. So I just want to be clear on that.
I would add before we Randy, if you could unmute Carolyn, but that is the same policy as I said earlier with the mortgages. We have the information that would be associated with units, but the whole board did not receive that. And I personally removed all the identifying information, the units and the names. So the only information the board has is how many mortgages there are and the price of each mortgage. So with that, Carolyn, it was your question.
Yeah. So first of all, mortgages are public record. And if you are filing liens on the people who are delinquent, all of them pursuant to the process that we set forth, that's also public record. But we are owners of this building. We own a share of this building. And number one, for the last almost 3 years, Jim and I have been paying over $2,000 a month. So don't tell me I'm not subsidizing somebody in this building, because I am, because there's $500,000 of unpaid dues out there, and we're using insurance money to pay our bills. So we are subsidizing. And there's no reason, if you're going to file a lien against somebody, it's going to be public record. So then file a lien against everybody like the governing documents. I mean, this is crazy. We are circling the drain here, and you people are acting like we're getting, millions of dollars for this building, and we're not. But all of this will be public record at some point. That's all I have to say.
I think we'll discuss that further among the board. Points
Well,
taken,
and
Carolyn.
thanks for that, Carolyn. As we mentioned before, liens are being filed, and that is, you're absolutely right, that is public record for that out there. But for us to specifically share the owner's financial information is not something we would do. But it is public record, to your point.
So can you unmute Michelle, Randy?
This is a follow-up to what the conversation what Carolyn said. Tracy, the owners who are in arrears, obviously the process will be followed about liens and fees. So when you say that that will be deducted, so will that mean that for the owners who are paying their fees, that will increase their portion of the pot because it will be made greater by balancing out? Is that correct? Is that my understanding?
That is correct.
Okay, move along. HO6 insurance. I think that's yours, Randy.
Okay, all right. Question is, why do we need to maintain some insurance on our units, and how do we calculate a reasonable amount to insure them for? The short answer is, in the declarations, that it states there that each owner must maintain an HO6 insurance policy. And the Blue Book in section 19.2 expands on the requirements of that required policy. At this point, now the declaration could be changed with 75% of the affirmative vote, but until that's done, we as a board have to enforce the declaration as near as we know about it. As far as the amount of insurance that you should get, again, I'm not an insurance agent. I'm not a lawyer. I would say that you should consult your insurance agent or an insurance professional to determine what amount of coverage you should have. Explain what is the condition of your unit, what is in your unit, and maybe even show the 19.2 section of the Blue Book, and have that discussion with your insurance professional.
Dan?
And your mortgage company.
Yes, good, thank you. I skipped that line, didn't I? Yes, mortgage companies have an insurance requirement quite often as well, and you should check your mortgage to see exactly what do they require. So I know that's probably not a very satisfying answer, but that's really about all I can say.
Steve, that was your question?
Yes, it was. And seems to me I'm not a lawyer, of course, that this whole reliance on the Blue Book business at this point is getting a little ridiculous. We're not going to have a building with people living in it. What does that have to do with the Blue Book anymore? But getting back to the insurance question, if all our belongings are out, the only thing that might be left, say to be destroyed by another fire, are the additions that we've made to inside the studs, as we've said so many times. But that being the case, it's clear that the amount of money that we will receive will barely cover outside the studs for the size of each unit. Won't cover the inside the studs that we paid for, and people have put hundreds of thousands of dollars in some of their units, upgrades and so on. So to have any kind of insurance other than liability, by the way, Greg told me the only thing you really need is a liability policy. You'll have to get Greg on in line with what Randy just said. I just talked to Greg the other day, and that's what he told me. So this insurance thing seems very weird to me.
What I've heard from talking to Greg is is just liability would fulfill the declarations and in the circumstances would be sufficient. It's difficult to get it, but we think that's sufficient. Okay, electrical bill. Another question from Steve. Tim, you were going to handle this one?
Yeah, basically, the electric is off in all the units above the 8th floor. They've all been locked out. They've all been locked out at the electric panel. So there is no electric being used on those units. And as Tom indicated earlier, we're having an engineering study done to tell us what we need to do to preserve the building integrity going forward when there's nobody living here. So if we were to need to install HVAC units in somebody's residence in order to keep the building safe and protect it, the association would take over that electric bill. Basically, what we have to do is we have to go in and rewire the unit a bit so that we can turn the HVAC unit on, but not turn on the rest of the electric in the unit. So we may at some point in time have to go in and modify a few units to add HVAC units to keep the building from being degraded. And at that point in time, the association would pay the electric bill in order to keep the building safe.
Chris?
Yes, I am getting, I'm on the 10th floor, so my unit has no electricity, yet I continue to get a monthly electric bill between $10 and $11.50. And I'm told that's because I have an account. Now my question is, can I cancel my Duke Energy account for my Hammond North unit?
I believe what Greg has told me for not your situation, but other units is we need the electricity to be on potentially, and would have to, again, as Tim says, rewire that. But that once you've moved out, you can turn your bill in to Greg and he'll reimburse you for that amount.
Okay.
And it's much more difficult for him to take over people's account, but he can reimburse you for it.
That's what we're doing.
Okay.
So we were doing the reimbursement, but we just shut ours off. And if you shut it off, it has to go back to the bulk account. And to the point that if the electric needs to be turned back on, there will be a cost to the association, regardless if it's reimbursed or going back to the bulk account. It's at a cost.
So you canceled your account, Tracy?
I did.
Okay.
And there's a chat that says, someone put on the chat that they have canceled theirs. It's been canceled for a couple of years now.
Yeah, I would just urge that people below seventh floor and below, that we would need we may need those HVAC units on from time to time. One for the humidity in the air, and while there's pipes with cold water in them, there's some moisture, but also especially for winter. So I would just advise everybody talking to Greg about that and working what they can work out.
And once everybody is out of the building, it'll probably be easier for Greg to go back into the bulk account versus collecting everyone's bills and then trying to see reimbursement checks. So yes, they should talk to him, but it would be easier if it went back to the bulk account.
All right, so the next item is Alta Fiber. Chris, you want to handle that one?
Oh, I do want to handle that. Hold on, let me get my.
Wish somebody would, huh?
So the question is, for the last 6 months or more, owners have been asking about canceling the Alta Fiber contract. Why are we continuing to pay for cable and internet service for a few people still living in the building? And what is the status of the Alta Fiber contract? And that was submitted by Lynn Stahl. So here's what I know about that. After the February 23rd fire, Greg contacted Alta Fiber, and they agreed to give us a credit as units were being vacated. That credit has been building over 2 years. The plan was to use that credit as units once again became occupied. That was the plan, and as you know, it hasn't worked out. If we were to terminate the contract before the end of its 5-year term, which ends May 7th of 2026, we would have to pay the entire amount of the contract. In other words, there would be no savings to the association. The same was true of the previous 5-year cable internet contract. So this is a standard provision in many contracts. And I'll go on for there. The only means for canceling the Alta Fiber contract is the force majeure provision. Now, to explain what that is, it refers to extraordinary events, circumstances beyond the control of the parties involved in a contract, which may excuse one or both parties from fulfilling their contract obligations. That would include natural disasters, and in our case, that's the fire. So the fire was the extraordinary event, but the force majeure provision was not applicable until we voted to stop the rebuild. That did not happen until the very end of March. And Alta Fiber was contacted in April, and the force majeure provision was invoked. However, the April and May bills were paid. We have met with representatives from Alta Fiber 3 times. And in accordance with the terms of the contract, the May bill has been contested and no further bills have been paid. There's a large credit with Alta Fiber. It's about $165,000. We will be meeting again with them in late July or early August, and we are working to find a resolution to the problem. And that's all I have to report.
Lynn, do you have any questions?
I don't think Lynn's on the call.
Okay. All right, owners meeting. When's the next owners meeting? And the board has talked about that a number of times. We haven't set a firm date, but it looks like September. We'll probably convert the board meeting into an owners meeting. But we'll let everybody know by one call when we make that firm decision. There was some back and forth among the board before we received this question. The second, that was from Lynn. The second question from Dilip is that he thanks us for our transparency but meetings and executive sessions are not appreciated. He'd like owners to be able to observe all executive sessions, but not ask questions. And actually has a suggestion of reverse. Otherwise, can the board reverse the order of the open and closed meetings so that they can inform members of at least some of what transpired at the executive meeting? Regretfully, with some members of the board working, it would postpone the regular meeting much too late, I think, for people to 7:30 or 8. So I don't think we could do that. So I think we have to sort of keep it the same order unless we separate it out, and then that impacts on 2 different days for people. As much as I sympathize about that, there are going to be conversations all boards have had between different members. And it's only when it gets to 5 members, then it becomes a quorum, and then we have to announce them. And that's what we have done. As much as I sympathize with it, I think for the effective organization of a board, I think there is a role for executive meetings, especially like we were briefed by Ian Mitchell about some of the legal orders. I think some of those discussions about personnel, which we've taken action on, and there are fewer staff, and we are going to have a party for not officially our employee, but for Jean. We'll have a party at 4:30 tomorrow. So that's, I think, what we're doing at this point. I don't know if Dilip is on the call or Lynn, and Lynn is not on the call, but that's the answers for those questions. Kate, I see your hand is up. I know you asked about the Burnham lawsuit, but go ahead.
Yes, I'm wanted to find out the status of that, and that may be significant as far as our collecting some money towards our.
Well, I would say this about it, is that there are a number of lawsuits, many of beyond that the board has filed, that there are a number of units, we think about 15 from at least 2 or 3 different insurance companies that are what's called subrogated claims against the owner of 108, the Burnham claim. And that's because they have paid the owners under their claims, and they're then turning around trying to recoup that money. More than that, I know that there are updates or meetings with lawyers, but I really don't have any more details to share on that one. All right, the next question was closing down the building, and I think those are mainly going to be Tom or Tim, divide that up. Do you want to go for that, Tim?
I think Tom said he was going to try to take that on.
Okay.
He's muted, Randy.
If you can find. Who is it?
Tom Dees.
Where are you, Tom?
3rd row down on my screen.
Next to Tim.
Raise your hand, Tom.
And if you can see him, John, you do it.
No, I can't do it. I made you host because of if you could make me co-host, I could do it.
Tom, raise your electric hand.
No,
He's
the
raising
electric.
them. He's raising them.
The electric hand.
Those aren't electric. Okay, there. Unmute yourself, Tom.
It's listed under reactions.
There I
you go.
am. Got it.
Tom's on.
Okay, so where were we at? I was busy raising my hand and waving and all that.
The first question from Mary Merriman about mail.
Mail?
Will we still get mail after the first week in August? Will postal service?
I'm not
Yeah.
sure I'm
Postal
right one.
Amazon not be allowed in the building.
That goes back to our question about keeping the building open until the end of September or sometime in October. So you can get in and get your mail until sometime in September at least.
Right.
Okay.
And then Carolyn Ford's question was about what we were talking about, Tom, closing down the building.
Yeah, Carolyn, that question pertains to the H&V discussions that we had with this morning. And, we're kind of looking for some guidance on what's the prudent thing to do. So as we don't, concerns are if we freeze pipes and if we have water pressure on the pipe, it'll leak and cause a lot of water damage. Although our plan is to probably shut off and drain the water, which means you could freeze the pipe, but you wouldn't have much water damage when it thawed out until you turn the water pressure back on. So also another concern is, if you have water dripping off lines, it could cause mold. Uh, Mold could affect the value of the building. So we want to try to touch all bases of shutting the building down, not only to save money, but to do it in a way to preserve the value of the building. I hope that answers the question.
There was also a comment, there was an ending comment about getting TRS and Hunt out of the building. That's pretty much done.
Yeah.
There's very little work being done. Hunt finished up. They had to repair the porches. The city of Cincinnati, as part of the permitting process, when we took the hoist down, there were holes that were drilled into the balconies. Hunt finished repairing those this week. TRS took the hoist down, so they should be out of here. We will have one more invoice probably from each of those companies, but it will be significantly less than it has been in the past. And for the most part, Hunt and TRS are out of the building.
The only thing that might come up is if we find out that we have to put in some of these H&V units to maintain value of the building.
Right. And there's a question about why there's still a dumpster here, because they were still disposing of drywall. They were still doing some drywall work in accordance with what the city asked us to do. So the dumpster ought to go shortly now, because there is no more work going on.
I'm looking at the chat, unrelated. We have got a number of requests, and there's one in the chat about the problem of owners getting compensated for appliances, where it was back and forth between HOA and HO6. And owners have requested letters from us that detail what the situation owners are in. And we are discussing that. And I can't say for sure, but I believe we will issue a letter for each owner who requests a particular letter for their insurance companies if we can.
There was another question on the chat that says that aren't you interested in the offer that you received today? Maybe you won't have to shut down the building. Here's the deal. If we had a totally clean sale, if we had a totally perfectly clean sale, it would take weeks, if not months, to make the sale. With as messy as this sale is going to be, there's no way that we can have an offer done and keep people in the building beyond what the city has told us we have to do. A clean sale means that everybody has agreed to the sale, and we just go write the contract and make the sale. That's a clean sale. We don't have a clean sale because we don't have the membership vote yet. We have mortgage issues that we're still working through. So there's a lot of messiness associated with this sale.
Randy?
Yeah, first of all, John, I made you host again, but I unhosted myself. So if you want to put me back in as a co-host. Yeah, along that line, there was another chat question earlier on that I was going to get to. Yes, we did receive a written offer today from Mike Stacy. The basic price is $12 million, but there are many issues connected with that we need to iron out. So, it's not a done deal at this point. Question was asked, if it turns out to be a good offer and everything else, we still have to get 100% of owners to agree. I was asked, we were asked, do you think that more people then would sign the agreement to sell? I don't know. I hope so. It's either that or go through a long partition action. So I think somebody else put a comment in the chat about, something about, I don't know, why would people not want to agree to sell the building? And yeah, I hope that does move. I can also say that today we walked through the building with our broker and an investor, well, his whole group of investors. It's this group of people that are investors in the same organization who are interested in the building. And hopefully we will get an offer from them very shortly. And our broker is also positive that more offers will come in the next weeks. So yeah, I know a lot of this has been kind of negative tonight, but there is some hope out there anyway. So I hope that gives us something to cling to there.
Hey, Randy,
Yeah.
is it true that if we change the governing documents to 75% sale, that we would only need 75% to put the building up for sale?
Yeah, John spoke about that. Our lawyer has talked about that as well. And basically, I can just repeat what John said. He said it pretty clearly. Yes, legally we can do that. If we get 75% to agree to change our declaration to allow a sale of the building with only 75% of owners agreeing to it, we can legally do that. But there is a good chance that that would be challenged in court. And our lawyer feels that courts are very wary about taking away owners' rights. And so we might likely lose that in a court case. Ethically, in my own opinion, if you just want it, it's kind of unethical if you ask me. It's like we're in the fourth quarter of a football game and we decide to change the rules that the people with the fewest points win the game. It just doesn't seem ethical. But that's, yeah. And the lawyer thinks it technically is legal, but probably we would be on very shaky legal ground if we tried it.
It would probably end up in the Supreme Court of Ohio and take years to get through it.
Okay.
Yeah, well, I mean, while it's not, I think it's not specifically illegal. He talked about how important individual property rights are and how protected by the courts they are.
Yeah, and that came up in the Porter lawsuit also with Judge Nestor. I mean, there was a lot of discussion in that about how strong personal property rights are. So it like John said originally, our guys don't think that there's a good chance of us being able to win that.
Let me just say also, the board has to make hard decisions. And a hard decision means, in essence, in many places, in many situations, that some owners are going to be happy and some owners are going to be unhappy. But we have to make our best judgment that we see it. Situations change, maybe we'll feel otherwise, but that's a decision at this point in time.
Well, the other thing that I guess I don't want to underestimate is Jan talked about it earlier in the meeting, and there are a bunch of comments about right now in the chat about why wouldn't people sell the building. Jan has this group, and their charge is to talk to these people, and our broker has said that he will come in and talk to people if they want to. Mike Stacy has offered to come in and talk to people if they want to. We've hesitated to do that right now because there's too many unanswered questions, and it would just generate too many questions that can't be answered right now. We're trying to pin these offers down as best as we can so that when we do bring them to the ownership, we have most of the answers and not more questions than answers. And that's where we are right now. Where we are right now is there are more questions than answers. And we need to pin down some answers before we feel like we can make that presentation to the ownership.
So to move
I
on,
would echo that point, Tim, that it's really hard to get a lot of the answers when we're not under contract. And so in order to do that, we need for the owners to vote to sell. So it's almost like a rock and a hard place where we're putting our best foot forward, thinking that this will come to fruition, but it just is not happening right now. So to Jan's point earlier, we really need to focus on getting the building sold to try to get the most money for every owner.
And may I go?
yeah, Jen.
There was a question in the chat about or asking how it was going. We don't have like huge numbers to report yet, but the value of these one-on-one conversations is amazing. I mean, anybody who does grassroots organizing, it's a testament to it. And I really think that's going to be where our strength is. Tracy's talked to some people. There are more people on the list to call. If anybody else is interested in this process, or feel free to contact me if you want more information about it. It's kind of amazing to see what might be possible. Everybody has different concerns, and I understand that. You're talking about people's property again. And so people do have a lot of questions, and they deserve to have them answered. So we're taking them one at a time.
Jan, how many did we say we had left to go?
Oh God, I don't know.
On what?
Tim, you just said
On the vote to sell.
The reserve vote,
128.
we have 127 positive votes, and the sale, we have like 124.
Yeah. And there are a couple more that have come in. But we haven't, Greg's out of town. We can work with Mickey to open the ballot box, maybe on Friday. But I think the real work of the committee, you're going to start to see better numbers in a week or so, because this takes time. Oh, thanks, Carolyn.
All right, I'd like to move the discussion then the last question, which is about taxes, that we're able to lower the taxes last year, and have we looked into lowering the taxes even more? I'll follow it up personally on that one, and I contacted an individual that we were talking to a year ago about lowering them successfully. There is an additional method to do that. The window is only January through March. So if you send the form in earlier, it'll just be rejected. And I don't think you get a notice on that. So in November, December, we'll get in contact with them. We'll get the information, and we'll send that out to all the owners. Unlike the previous method, it's an individual method. Each owner has to submit the form for themselves of what their damages is. And certainly, I think the units from 9 and above that have ceilings removed, unlike when we first reduced it, that may be possible to get them lower, but the city tax man did not have a firm answer on that. So that
Jan?
was Marge's question if she's on the call.
Okay.
Anybody else on the board?
Jan, you put your phone number in the chat, and you missed a digit.
Oh, thank you.
Hmm.
That wasn't intentional.
Yeah.
Kind of.
All right, those were the questions that we got in by Friday, or actually, I think we extended to Saturday. So that's the questions and answers. And with that, I think we'll adjourn. If there's a motion to adjourn.
I want to make one more comment, John.
Sure.
Like I said, we had an owner approach us today who said that they have questions about the resolution, that they're concerned about the clarity of the resolution, and that they thought that there was a number of residents who, if we clarified the resolution, would come on board and sign the resolution. So please, if you have questions about the clarity of the resolution, get those to us so we can address them, so that hopefully we can get this next block of people over to vote positively for the direct sale.
So, Ginger, you have your hand up. We were only doing questions tonight on the questions that we had read through. I don't know if you were on the call for that. If you want to make a short comment, okay, but we'd like to wrap up the meeting.
Yeah, I think I'd just like to say that I'm on Jan's committee and we've been calling people. Everyone I've called has been asking questions and ended with, yes, I'll send my vote in now to do the sale and to drop the amount of the vote. However, it's really disappointing, meeting after meeting, to see the board discussing such serious matters and taking positions that that protect us, they think, when in fact most of us, in talking to people, realize that the great majority of the building wants to get out from underneath this nightmare. And not only does it happen that way, it happens with no motion. It's a general vague discussion that's going nowhere because there's no motion to respond to. A lot of us would like to see, out of the 7, how many board members are willing to take a step like that and how many are not, and who are they, so that we can have conversation about it. But it needs to be in protocol following a motion instead of a bunch of loose discussion with no motion on the floor. That's my suggestion.
Virginia, can you elaborate when you say motion from the board? What exactly do you mean?
All of the discussion that was taking place that I heard was on the issue of, can you take people's units away from them, which is a valid discussion. But there was no motion on the floor about it, correct?
It was an answer to a question, I believe, wasn't it?
That's
Right.
correct. We had a question and answer period. We were answering each question.
So why doesn't somebody make a motion on those issues in order to sort of put it to rest so we can move on with it?
Because our attorney advised us against it. He told us that we won't win.
And I would also add, Ginger,
It will lead to another prolonged court process. It will end up in the Supreme Court.
I heard it. I heard all of that discussion. I don't have to go further.
Okay. Good enough. So
Disappointing.
we'll adjourn then until executive session. Thank you very much.